Professor Stuart.
Good afternoon, Senator. Thank you very much for inviting me at this late stage of your consideration of this bill. My brief was 3.5 pages, and I believe it's been distributed in English and French, so I'm not going to repeat it in detail. And I'll just try and hit the highlights in about 5 minutes. First of all, I want to say in a rather dramatic way that in 1995, I was nearly killed by an impaired driver. And my vehicle was totaled, and I was very hurt. But as a lawyer, as a law professor, what was intriguing to me was that the Kingston police managed to achieve a conviction and a 3-year sentence without following any of the criminal code provisions. I sat as a law professor watching in front of me the laws being not followed. And so when we pass a big, complicated, important bill like this, we have to be on alert to the thought that not all police officers will be trained well enough to follow explicitly. So we've got to be careful. So the only point of my attendance today is to try and refute the view of Peter Hogg and the Minister of Justice that taking the reasonable suspicion test out of the approved screening device is constitutional. I have no doubts in my mind. I believe you had 2 defense counsel saying the same thing earlier on. I have no doubt at all that there will be clearly constitutional challenges to that reform. For a very long time, we all, the Supreme Court tell us that because of the evils and dangers of impaired driving, we're not going to have the Charter stand against the random stopping of motorists or the random stopping by a single officer in the country for the evils of impaired driving. So that's arbitrary detention that it's saved under Section 1. That's not a debate. What has also been clear for a very long time is that in the initial stages, the inquiries have to be limited by police officers to vehicle-related reasons. Can't go looking for crime, that's a different regime. You can't search vehicles. We had an OPP officer the other day who said, it's my practice on the 401 when I stop a car to search every part of the vehicle. And the Ontario Court of Appeal overturned that conviction. All right, so as long as it's vehicle-related, it's all a go for police officers for very good reason. But what's not all a go is the way you find evidence of impaired driving. And so traditionally we have the approved screening device, and for a very long time we've had the requirement of reasonable suspicion. And under Section 8, that's been the standard. And this bill would take that away in the case of investigations of impaired driving when the officer has an ASD device on hand. Now, Professor Hogg and the Minister relied on an old case called Collins, in which Chief Justice Lemire said, this is Section 8, the test for Section 8. A search will be reasonable if it's authorized by law, if the law itself is reasonable, and if the manner in which the search was carried out is reasonable. So that seems pretty easy. It just looks like you ask yourself the question, is this law allowing an approved screening device without reasonable suspicion reasonable? And Peter Hogg can rely on his roots in Australia and New Zealand and saying, well, they're doing it now and it's detecting impaired drivers and it's a deterrent. Well, the only difference between New Zealand and Australia and us is they don't have a Charter of Rights and Freedoms that's entrenched. And I don't think it's a good idea for Parliament to be proposing something which is so clearly up for challenge. All right, so why am I so confident in that? Well, because there are literally hundreds of cases on Section 8. None of them turn on, does the judge think the law is reasonable? This was just a term of art and summary that Chief Justice Lemire put in place. The question completely omitted from Peter Hogg's brief and from the Minister of Justice relying on it is that the controlling authority for Section 8 is Hunter and Southam. Hunter and Southam is one of the most important judgments ever written in the Charter. It talks about a purpose of interpretation. It talks about privacy interests are protected by the standard against unreasonable search and seizure. It also says in a later decision, they said you're not supposed to ask it you have to ask the question in a neutral way. You don't say, in this context, for example, do you think that drunk drivers should not be able to be searched because there's no reasonable suspicion? No, you ask the question about, do you think the privacy interests of all drivers are upset when police officers routinely are allowed, without any checks on their powers at all, to submit people to approved screening devices? So Hunter and Southern would go as far as to say, you start with the assumption you have to get a warrant. Well, of course you're not going to, nobody's going to suggest that you get a warrant for a random stop for vehicle-related reasons on the highway. But Hunter and Southern says if there's no warrant, then it's a reverse onus that the Crown has to prove that it still doesn't violate Section 8. And they usually insist on reasonable and probable grounds, which is the standard for the breathalyzer test, stage 2 of investigative impaired driving. But sometimes over the years, over the 30, 40 years that we've had the Charter, the courts have backed off of it. They've backed off the reasonable and probable grounds, saying that that's too tough on law enforcement people. And so, for example, with the screening device, it's reasonable suspicion. So with dog searches, so also with investigative detention. Investigative detention can be when police officers stop pedestrians and when they stop vehicles. And they can't do it under the Charter unless there's individualized reasonable suspicion. And the court's made it very clear that just a mere routine, a subjective hunch or a generalized suspicion isn't good enough. I'm getting near at the end of my pitch for questions, but I just want to point out the Supreme Court of Canada has never saved a Section 8 violation under Section 1. Not one case since 1982. So Peter Hogg sort of has a fallback. Well, if it's not reasonable, it's saved under Section 1. No, not yet. Now, I'm not saying when the challenge comes there couldn't be a change, but it seems to me highly unlikely that the present court would change. All right, so what's the worry about taking out reasonable suspicion? The worry is undoubtedly racial profiling and the police force against racialized groups, indigenous people, vulnerable groups. Now, I'm always a bit reluctant to state that. I was a prosecutor. I've worked with police officers. Are all police officers racist? Of course not. And for many times when you assert that, they're very upset. But there's no doubt at all with the empirical data that we've had in Toronto, Vancouver, Saskatchewan, elsewhere, that there's no doubt at all that investigative detention under the practice of carding has resulted in huge racial discrimination against vulnerable groups. And there's no basis to suggest that if you give the police the power when they've already stopped for random vehicle reasons, that they can just do whatever they want on a racist basis. And there'll be no check against it because it'll all be legal. And so that's exactly why the Supreme Court of Canada has put in place a standard of reasonable suspicion. I also find it telling that the authors of this bill keep reasonable suspicion for the other part of the bill, which I'm not going to talk about, the one about oral fluid screening. That's going to require reasonable suspicion because I guess it's more controversial. Well, I'm here to suggest that this is controversial as well, and it's a dangerous power to put in the hands of all police officers in Canada, and I think it will clearly result in a charter challenge. Thank you.
Thank you, Professor.